The first presenter is Parker Moore. He co-chairs Beveridge and Diamond's Natural Resources and Project Development Practice Group and leads its NEPA, ESA, and Wetlands section. He serves as outside counsel to the Oil and Gas ESA Coalition, which is developing a multi-state, multi-species habitat conservation plan, and represents the multi-industry Rusty Patch Bumblebee Coalition. Parker is trained as a wetlands ecologist with years of experience delineating wetlands, surveying for endangered species, and drafting NEPA documents. Next, we'll have Tim Mayle, who is the Executive Director of the Environmental Policy Innovation Center, whose mission is to build policies that deliver spectacular improvements in the speed and scale of conservation. Previously, Tim worked at the White House Council on Environmental Quality, overseeing work on drought, water, wildfires, forests, major ecosystems, and wildlife. He has 15 years of experience working on agreements with businesses, states, and landowners involving regulatory assurances and conservation. And then we'll have Lori Nordstrom, who is the U.S. Fish and Wildlife Service's Assistant Regional Director for Ecological Services in the Midwest region. She has oversight of the region's Endangered Species Division, which has the lead for evaluating the monarch butterfly status under the Endangered Species Act. So welcome this panel.
Well, thank you very much. I'm pleased to be with you today. I really think that the efforts of this working group are extremely important, and really excited to see such a broad range of interests that are present and participating today. Now, I love this. Well, Iris asked me to talk about how to get business interests engaged in endangered species and conservation issues early on, and before the law actually requires them to do that. And I really love this issue because I think it's something that we all can relate to. I would say that you know, anyone that's ever held a job anywhere has had an idea about how to do it better. And you know, sometimes it's a little self-serving. Like the time I tried to convince my wife that it was terrible to mow the grass when football's on. Other times it's something that has far better or far wider implications. It has something that has greater benefits for people. And that's exactly what we're here to talk about today, because taking early action on Endangered Species Act issues and conservation is something that can do a great deal of good. It's something that does a lot of good for you. It can do a lot of good for your company. It can do a lot of good for society, and obviously it can do a lot of good for the environment. So let's get started. I'm going to start by giving you a couple of recommendations of if you are in business, how you can recommend to your decision makers, how you can recommend to your in-house legal departments how to get involved or why to get involved early on. And then I'm going to give you a case study of how that can play out in practice. So I'm going to begin by asking you something. What is the worst answer that you can give to a business question? Anyone have any ideas? Right. So when I first broke the news to my parents that I was going to be a lawyer and shattered their dreams of me doing something far more respectable with my life, they gave me some advice. They said, you know, son, there are 1,000 different reasons why we hate lawyers. But one of the biggest reasons why we hate lawyers is because you ask them a question and they don't give you an answer. And if you ask a lawyer a question, they'll look you straight in the face and say, yeah, it depends. So, yeah, it depends, or maybe, or, well, if you do this, then, well, there are any number of ways that you can say that, but no matter how it's said, it sounds like fingernails on a chalkboard, right? So the same is true when making business decisions. Maybes and possiblies don't cut it in the corporate world. So let me give you an example. You're sitting in a business meeting and the boss says, hey, John, can we build our project right there? Maybe. Hey, Mary, are we going to stay on schedule? Well, we might. Or, hey, Jimmy, are we going to be on budget? Man, I hope so. Those sorts of things just don't fly. Certainty is what's crucial. So the first way that you can make the business case to management and in-house legal is to explain to them that doing this, getting involved early, getting engaged in Endangered Species Act and conservation issues, can increase regulatory certainty. Now, you might ask, how can I explain to them that this is going to increase regulatory certainty? Well, I mean, Halloween's right around the corner. You could consider scaring them. And to project developers in this country, one of the most terrifying things out there is this. These are the range maps of the major pollinator species that the Endangered Species Act has its eyes on. In the top right, anyway, right up there, you all know what right is. In the top right, you can see the rusty patch bumblebee. I think pretty much everyone knows that Fish and Wildlife Service listed the rusty patch bumblebee as endangered this past March. Many of you may know that just 3 weeks later, a highway project right here in Illinois was temporarily enjoined because of the rusty patch bumblebee. Now, just last week, the Center for Biological Diversity has given notice to the Fish and Wildlife Service and the Federal Highways Administration that it's going to challenge that same project also for the rusty patch bumblebee for faulty Section 7 consultations under the ESA. All of this could have been avoided by early engagement. Okay? All the other species that you see up here, you've got the monarch, the regal fritillary, the western bumblebee, and the yellow-banded bumblebee are currently under consideration by the Fish and Wildlife Service, also for listing under the ESA. And as you can see, collectively, their ranges cover the entire continental United States. So taking steps now will allow your company to be prepared with a game plan. And as Tim and Lori are going to talk about here in just a minute, it can give you certainty, something that the Fish and Wildlife Service calls assurances. So the next two ways that you can make the business case for getting engaged early on ESA and conservation issues are somewhat related. First, you need to participate early on so that you can have a seat at the table. And secondly, you need to get engaged early on so that you can lead your industry where you want to go. Now, the notion of getting a seat at the table is pretty straightforward. It's important because when it comes to regulations of your industry, something that affects one of you is generally going to affect all of you. Okay? But you can't rely on other companies in your industry to do your bidding. Okay? They're going to be looking out for their own interests. Your competitors are not going to be looking out for your interests. That's why they're called competitors. So if you want to, so you need to get involved early, and you need to get involved. You need to get involved, and you need to get involved early, so that you can represent your company's interests. By the same token, if you get involved early, and you can help set the direction of these initiatives, and you're going to be ahead of your competition. You'll have a much better opportunity to direct where things are going to go than those who get involved later in the game, or those who don't get involved at all. And you've heard the expression, lead, follow, or get out of the way. When it comes to major ESA initiatives and conservation of endangered species, you want to be a leader. You want to be at the forefront to decide where things are going and how they get there. You also wanted to be involved early so that you can ensure that any solutions that are reached are going to be broad enough in scope that they cover your activities, that they are workable for both you and for your clients. And you can't do that if you don't participate. And it's hard to do that if you come in late in the game. So two more reasons for, or two more ways that you can explain to management and decision makers and in-house legal why it's important to get involved early on in the ESA game. Number one, it just looks good. Many companies at this point have incorporated corporate social responsibility and environmental protection into their internal policies. Conservation achieves both of those things. And it makes for excellent public relations opportunities, something that you can tout to shareholders, clients, public, and the press. It also helps to enhance your credibility with regulators. We all know that you can never have too many allies. You can never have too many good connections. And when it comes to having connections with government regulators, that goes double. Not only will participating in these sorts of initiatives allow you to establish a network of contacts that would be extremely difficult to establish otherwise, it helps to demonstrate your company's commitment to the types of things that the federal regulators are most interested in. That can pay dividends in a number of ways. I've seen several companies recently that were able to resolve potentially significant enforcement actions amicably because of past interactions with federal government. And the federal government knew that they could trust what these companies were saying and that they were a good corporate actor. I also have another client that is somewhat of a sounding board for headquarters level staff of a federal agency, where the staff at headquarters are bouncing ideas for new policy decisions off of this company, all because they know that this company is a responsible corporate citizen and that they have a commitment to creative conservation. That sort of thing won't happen if you're not involved in these types of efforts. And these things are absolutely invaluable, which brings me to my final point on how you can make the case. It makes good business sense. It can save a lot of money. And I'll show you exactly what I mean in just a minute. So before we close, let me share with you a recent example where getting involved early in ESA and conservation issues paid huge dividends for industry. And that was with the recent listing of the northern long-eared bat. So way back in 2013, we learned from our contacts at Fish and Wildlife Service headquarters that leadership was considering listing the northern long-eared bat as emergency endangered, which basically means that the service was going to automatically issue an endangered listing for this bat species without issuing or without giving notice or an opportunity for public comment. The reason is because of the drastic effects of white-nose syndrome on the northern long-eared bat. Now, we knew that while the bat most definitely was suffering significant effects from white-nose syndrome, which is a horrible disease. It's not sugar-coated. But that the species has been experienced, or that the species still exists in healthy numbers in other areas of its range. That, by definition, would exclude the species from being emergency endangered. So we worked with several companies to talk with the Fish and Wildlife Service headquarters early on and to show them the information that we had and to help convince them that if they list the species as emergency endangered, they were going to get sued and they were going to lose, and that rather they should take the opportunity to use the ESA's normal channels for proposing listing decisions. The service ultimately did that. In October 2014, it issued a proposed endangered listing using the normal channels under the statute rather than the automatic emergency endangered listing. And in its notice, it explained the bases for its decision and solicited public comment. We looked at the rationale underlying the listing decision, as well as the data and the studies that the service relied on, and determined that at most the species might warrant being listed as threatened. It didn't meet the definition of an endangered species. But we thought that actually was a great thing. It was good because it provided a better chance of conserving the northern long-eared bat. That's because everything that we saw, all the information that we put together, showed that the lone population level threat to the northern long-eared bat was white-nose syndrome. Human activity and human influences were not having an appreciable effect on the species population numbers. So what that meant is that a threatened listing was great. An endangered listing, all it could do would be to prevent human activities from affecting the bat. That's not going to do anything if the predominant threat to its survival is a disease. A threatened listing was great because it opened up opportunities for the Fish and Wildlife Service to bring more flexibility into its regulation. It allowed the service to issue what's called a 4D rule, which allows Fish and Wildlife Service to impose different requirements that enable it to better conserve species without imposing unnecessary regulations on the business community. So we worked with a coalition of 75 different companies and trade associations to put together comments that supported a threatened listing, opposed an endangered listing, showed the service why that was the right approach, and proposed a 4D rule. Our 4D rule focused on conservation. what we proposed is that the Fish and Wildlife Service set up a conservation fund. And what that fund would do is it would monetize the value of an acre of trees. So for every acre of trees that you cut, you would pay a set per acre amount into the conservation fund. Fish and Wildlife Service would then take that money and direct it specifically towards white nose syndrome research with the goal of finding a cure to white nose syndrome. Fish and Wildlife Service ultimately decided they pulled back the proposed endangered listing, proposed a threatened listing, and also proposed a 4D rule. They ultimately finalized both the threatened listing and the 4D rule. Surprisingly, the service did not, in the 4D rule, include a conservation fund. And instead, they decided to just exclude tree clearing activity for the most part from the ESA's take prohibition. But I think that while that was surprising, I think it shows the types of the innovative approaches that are available and the types of things that you can engage with the Fish and Wildlife Service on that allow you to interact in a meaningful way and establish those types of relationships. Now, I said that I was going to come back to the last point about how it can save industry money. And to that point, one of the reasons that you can give to management, give to in-house legal for getting involved early. The last estimate that I heard from the oil and gas industry, this was 4 months ago, is that every year the 4D rule has saved them over $1 billion. So you can see the benefit, and that's something that will resonate. Well, that's basically what I wanted to share with you. I hope it's been helpful, and we'll look forward to any questions during the Q&A session.
Good morning, everybody. Thank you all for being here. I'm going to start the same place that Parker did. This is one example of something that you think is your management target, but in reality, it's really this for these kinds of tools with the regulated species. It's your corporate counsel, it's your attorneys that work for the state agency, work for the governor's office. And monarch butterflies thrive on things that are toxic to us. Lawyers, general counsels thrive on an ecosystem that is toxic to us. But if you understand what it is that they need, what success in their job looks like, and you can figure out how to work with habitat management that benefits rare species, because you can help them deal with the thing that is their job, mitigating risk. Right? What they're hired to do, what they're it's almost in their DNA. If you meet people who go to school and then law school and end up in these positions, they're risk-averse people. So their approach is, how does this affect our risk? And if you can help answer that question, not about the science, not about the species, but about risk for the company or the state agency or the governor, you will be better off. This is the range map by county that shows where listed species are today. That little red space, it represents the portion of U.S. biodiversity that is currently listed. The blue space around it might be, that is all the species that state agencies have identified as species of greatest conservation concern. You heard Parker talk about the Center for Biological Diversity. That blue space is their target, right, for future listing petitions or anyone else. That's a conservation target that's coming next. So if you think about the fact that how difficult it is to work with just that little red wedge, and what we have coming is this much bigger wedge, that's a huge risk future for a lawyer. And what you need are solutions, and what we're talking about are solutions that help explain, help create basically a contract that mitigates that risk, that makes that risk go away in some form. And the better you can get state agencies and helpful counsel to work with you to develop agreements that really take away risk, the more habitat management you can do fast. Bees, there's 5,000 species of bees in the United States. No one has a clue on how many of that percent of species are declining, but you can be sure it's more than 3 or 4. Thousands and thousands of other pollinators. If you think about what your wildlife goals are, and we were talking about integrated vegetation management before, you're trying to avoid extinction per species. You're trying to avoid listing, a threatened and endangered listing. And you're trying to keep species up in the space where the federal agencies, state agencies don't really care about them. And so one of the key terms that gets thrown around, and we'll hear about this with CCAAs in a few minutes, is what is the biological goal of an agreement supposed to be? Are you trying to just minimize your harm? Are you trying to leave the species or the ecosystem or the habitat better off? Are you trying to manage for no net loss? There's a whole bunch of different thresholds, but you have to come up with this answer of what the threshold is, and the species, whether they're not listed or whether they're listed species, a different kind of regulatory tool under the Endangered Species Act. In some cases, state law applies, but they all work somewhat the same way. So I'm going to show you a graphical analysis of the whole space. So below the line, the horizontal line, is federal. There's a federal connection. Above is private. On this side, those are listed species, and on this side, they would be candidate species. So consultation on federal actions is sort of the biggest space in which people get permits or authorizations to be able to affect species. You have this whole ecosystem of other tools, safe harbor agreements, candidate conservation agreements, without assurances, with assurances, conservation banks. I think we'll hear about that from Randy a little bit later today. Recovery credits, a tool that's only been used in Texas. For candidate species, something called a conference report applies for federal agencies. Like the sage grouse was an example of a species that 1,500, 1,400 landowners, private landowners, mostly private ranchers in the West, were given assurances that they would not face more regulation on their land through what was a conference report between the U.S. Department of Agriculture and the U.S. Department of Interior. It says if ranchers are doing these kinds of things, they don't have to worry about more regulation. Pre-listing credits, the little bubble up there, is a new policy that hasn't had any activity under it yet. So there's this whole ecosystem of regulatory tools. They all work in somewhat similar ways. I'm just going to describe two quickly, sort of say you guys are not alone. Safe harbor agreements have been around for about 20 years. 12 state agencies serve as administrators of programmatic safe harbor agreements. There are something like 500 to 700 enrolled landowners. A lot of those landowners are people who own large areas of land, or they're state agencies, local agencies. Like a CCAA, there's a template approach, either where one administrator runs a whole program and signs people up without a federal agency necessarily being involved, or where there's something called a template agreement. The one I put in the slide is in Idaho, where there's just a document that basically has a few blanks on it. You fill in the blanks, you enroll landowners that way. It's got 16 landowners participating in Idaho. Habitat conservation plans are a bigger tool, and some of you, including Parker, are familiar with those. There's about 1,500 habitat conservation plans that have been put in place since the 1980s. During the Clinton administration was when they really took off. Those plans provide a permit to harm endangered species on 40 or 50 million acres, so they have very, very broad reach. There's an example is the NiSource natural gas pipeline network, or now TransCanada. So a tool, so you've got one tool with 500, 700 landowners, this tool covering many, many millions of acres. Conservation banks, as I said, I won't go into this in a lot of detail. Randy will talk about it, but there's roughly 140 conservation banks where someone is doing restoration on a property and they get economic value out of the restoration because they're creating a stock of credits that they can sell to somebody else who has a permit need. The map, the small map there shows the number of conservation banks that have been approved per state. So this is the diversity of tools that exists out there that U.S. Fish and Wildlife Service, state agencies, other experts are really familiar with. And you don't really have to know about how all those tools work. But when I think about the challenge of helping pollinators, helping the ones that are listed, the ones that might be listed, and a lot of other ones we just don't know that much about, the lesson that comes through in looking at and being part of dozens of these processes, looking at thousands of agreements, is that there's a bunch of lessons that apply no matter what across all of them. And I capture them by describing with these three terms: taking risks, how much risk are you going to take when you develop an agreement, how fast is it going to go, and what are you trying to achieve at the end of the day. And this is my last slide, so I want to spend a little bit of time on these things. These are, to me, the rules that can get you stuck in a process for a decade You can spend years going around the same question, or you can try to address these questions up front, get leaders involved, people who actually have the authority to make decisions, federal, state, corporate, whoever they are, and try to resolve questions like these. So you need, because we're talking about pollinators, you need to not focus on getting an individual action, very specifically described, approved. You need to talk about broad strategies. Like, what's the whole suite of IRV that we're going to cover with an agreement or a plan? How are we going to build a plan that covers not just the things we know about today, but a whole bunch of future plans without having to go through a new round of federal or other review? You need to have a very fast, very cheap way to figure out what your baseline is, because most of these agreements don't let you destroy what's already present on a property, generally trying to help something get better off. So you need to find a way to do that fast and cheaply. The choice between getting an environmental assessment and an environmental impact statement is a $2 million 3-year question, right? If you can do an EA, it'll be a lot faster to develop something like this versus an EIS. And in this administration, there is a lot of interest in moving everything into the path of doing EAs instead of EISs. And so thinking about how you build an agreement that mitigates the environmental harms so that you can get into an EA path very quickly is really important. It's a design question right up front. And if you wait till the end, you won't end up on that pathway. To help pollinators on the scale that you all are trying to help do habitat management, and with the number of species and the number of different kinds of actors, I was meeting with the Wildlife Habitat Council, who partners with corporations just last week. You need to find a framework that allows almost anyone to join the program without each one having to have a separate agreement, a separate framework, spend a separate period of 5 to 7 years developing a document. So you need a tool that a company can enroll partners, or a trade association can enroll partners, or USDA can enroll landowners, or a state agency can enroll people in the program, or cover their own agencies. And not focus on a process that always has Fish and Wildlife Service as the bottleneck on approval. Because despite the best of intentions, they have very small resources, very few staff to do this kind of work. And if you have the Fish and Wildlife Service as the decision maker on whether someone gets in or not into a program, you will always have this bottleneck that prevents you from achieving the kind of scale of enrollment that you want to have. And lastly, the point of all this work is to focus on the outcome. It's management cost per acre or per mile of roadside. It's whether the species and the ecosystems are better off or not. So you need to design programs that really focus on that outcome as opposed to all the procedural steps. And a lot of the agreements that have taken 5 or 10 years, they spend a lot of time talking about process and who's going to report to whom at which point in time, and not focus on the outcomes at the end of the day. And it's those outcomes that matter. So I'll stop there. Look forward to your questions afterwards, and I'll turn it over to you.
Good morning, everyone. Thanks for inviting me here. Good to be on this panel with some diverse ideas about how we can provide some assurances in the event the monarch or other pollinators might get listed. I've been on a couple of calls with you. I was on a call with some of you back in September, and I know we've had some conversations that the Fish and Wildlife Service has been present at talking about candidate conservation agreements. So some of my presentation might be a little bit of a repeat of things you've heard, but I wanted to frame what candidate conservation agreements with assurances are before we have more conversations tomorrow in detail about them. We have heard from a few of the folks in this room already specifically talking to us that they are interested in moving ahead with a candidate conservation agreement with assurances. Some of you may have heard that early on we were saying we were going to work on a template, we being the Fish and Wildlife Service, we were going to work on a template for such candidate conservation agreements with assurances, and some of you are wondering, where the heck is that template? And as I think I mentioned on the call that some of you may have been on a month or so ago, what we needed from you folks is, well, what exactly are the activities that you want to cover? We've definitely heard there's interest, but we need more specifics. So I think that's what I'm excited that this workshop and folks tomorrow are going to be talking more about. What could we cover? So candidate conservation agreements with assurances first came into play in the late 1990s. In the End of last year, there was a revision of the Canada Conservation Agreements with Assurances, I'm going to call it CCAAs, policy that clarified some definitions in the policy. So it was just updated last year. And the goal of this program is to provide incentives for landowners to conserve species so that we can help keep them from being listed, but then in the event they might get listed, to provide assurances to the landowners that the conservation measures that they're taking and the work that they're doing will be covered in the event the species gets listed. I see, just listening this morning, the huge amount of habitat potential for pollinators and conservation benefits for pollinators. I just sat there this morning, I was like, oh my gosh, we have got to tap into this, because you're already, I know a lot of you are already providing great pollinator habitat that can make a difference for these species. So Canada Conservation Agreements with Assurances, candidates are species that we had already determined qualify for listing. In the late 90s, when we came up with this policy, we had a huge backlog of things we said were candidate species that we'd already determined warranted listing. And so that's why this is called Candidate Conservation Agreements with Assurances. Since that time, we've gotten through that backlog. And so these are also applicable to species that aren't candidates yet, like the monarch butterfly, species that are at risk. And so it doesn't have to be restricted to candidate species. As Parker mentioned, there's, in addition to monarch, which we're going to make a decision in June of 2019 whether or not we should propose to list it. There's also the yellow-banded bumblebee, like Parker mentioned, regal fritillary, and some other pollinators that are coming up for review on whether we should add them to the endangered species list. So we could write a CCAA for monarchs, but also include these other pollinators, which would give you more assurances, which I'll talk about in a little bit. So keep your mind open to covering a variety of pollinator species if you're going to work on a CCAA with us. Goal of the candidate program is to take actions that reduce or eliminate the threats to unlisted species and improve its status to the point that it doesn't need to be listed. And that's where I look at all the potential habitat acres that might be available through rights-of-ways. That is huge. That could make a difference to whether or not we might need to list some of these species. Monarch, as most of you probably know, it has a range across the contiguous U.S. into Canada and Mexico. So it has this vast range. Some of the news you've probably heard that there's also a concern like on ag lands. Loss of habitat has been the big factor, we think. Loss of milkweeds for monarchs and nectar plants has been the big driver. But there's, I don't know, how many acres are possibly available through rights-of-ways. So huge opportunities. I did laugh when one of the speakers this morning put up a list, I think it was you, put up a list of I don't know if it was good plants, but weeds. And I saw milkweed was like the third thing as a weed on the list. But we need milkweed. So what are CCAs again? This is some of the repeat. They're voluntary. Nobody has to get into one. Voluntary agreements with non-federal property owners. It can also be for leased lands if you have the authority to manage the habitat or manage that land. So you don't have to actually be the property owner, but have the authority to manage that land. They're designed to address the threats to a particular unlisted at-risk species. And in the CCAA, it would identify the number of years that that CCAA is effective for. It's a tool to address concerns about providing conservation for the species in the future that might be listed, and federal agencies can participate, but they can't get the assurances, which I'm going to talk about next. They can't get the assurances that a non-federal landowner can get through a CCAA. So what is the standard? I've heard this over and over from folks, and then Tim talked a little bit about these other tools that we have, they all have different standards. And so the big one for a CCAA is it has to provide a net conservation benefit to the covered species. So a net conservation benefit. So I think of this for monarchs when the big issue is habitat, need for milkweed and nectar plants. Are you providing habitat over the term of that CCAA? It also has to address the key threats that are on that property. If there's other threats out there that that property doesn't have an issue with, you don't have to address them. But the key threats. Let's see. Did I just turn it off? Oh, there we go. So basic requirements as a CCAA, and these are the things that a CCAA would have to address, are what are the population levels of the covered species? What are the habitat characteristics of the property that you want covered? And a key thing is the conservation measures. What are the things you're going to do to address the threats that are on that property? What are the expected conservation benefits? And then the big thing, which I'll talk about next for landowners, is assurances. The assurance that if the species gets listed, we won't require anything more of you than is already covered in that CCAA if it gets listed. That's the reason to do this. And then there's a monitoring provision, and then if you're going to end up in the CCAA through this agreement, you're going to end up taking some of the species, a provision that you notify the Fish and Wildlife Service, so maybe we can come and take the species, move it elsewhere, something like that. That's just a small thing. So again, why would you want to do this? Because it provides assurances to you on your properties that if you have one of these agreements that provide conservation measures to address the threats over a certain time period, then if the species gets listed, provides assurances, we're not going to ask anything more of you if it gets listed. Also, the huge benefit in my mind is it could prevent the need to list the species by doing all these conservation measures. So there's two things. In my mind, preventing the need to list the species, providing that habitat that species need over a long term is huge. But in the event it still would get listed, it provides those assurances that you don't need to do anything more. So what's the process? I know people are curious about that. So first you have to develop a CCAA agreement that has these conservation measures and the covered activities that you want to address. So that's where I said we had thought originally a number of months ago, maybe even last year, we were going to work on a template agreement, but we needed to know what were the activities you wanted to cover so that we could think about, well, what would the conservation measures be? And so that's something that I think we're probably going to kick off some more discussions about tomorrow in that separate working group on what are the covered activities. I also see it, and I don't know enough about the different rights-of-way sectors, but the more I read, the more it sounds like a lot of similarities among the different sectors of, like, maybe you kind of are all doing the same thing. So maybe we could pretty much have one template that works for everyone. We have to do NEPA, and Tim mentioned, you know, keeping these things at a lower level, environmental assessment level. If any of you have read our CCAA policy, it actually says that we, the Fish and Wildlife Service, think that a lot of these CCAs could be categorically excluded. So that might be possible too if there's not a significant environmental impact from that activity. So hopefully it can go relatively smoothly. Then you would apply for a permit, because in the event the species gets listed, what you get that provides the assurances is an enhancement of survival permit. So we need to have that permit application. The public doesn't have to be involved in the negotiation discussions about developing a CCA, but because there's a permit that would go into effect in the event that the species would be listed, we announce it in the Federal Register for about 30 days usually, to let the public know we might issue this permit upon listing. And then there's what's called a conference opinion under Section 7 of the Endangered Species Act. We have to look at the authorization of the CCAA and the potential permit that we're going to give and its effect on other listed species. So that's something to keep in mind when we expand the range of where a CCAA may cover. That means there's more already listed species that we need to consider in this conference opinion. And then finally, the Fish and Wildlife Service would issue a findings document that finds that the conservation measures and issuance of the CCAA and eventually an enhancement of survival permit we find to provide a net benefit to the species that are covered under this CCAA. So we talked before in some of our calls about programmatic CCAAs and umbrella CCAAs. So a programmatic CCAA is one that involves multiple property owners enrolling under one regional or statewide agreement. And that's where it's overseen by one permit holder. And then each property owner would receive a certificate of inclusion under that, tailored to their individual property. That works like when you have especially a state agency that wants to be the holder of that programmatic permit. In this situation with a bunch of rights-of-way sectors, I have a little bit hard time coming up with who would be the holder of a programmatic CCAA. What I think, as I've been thinking about this, would probably work better in this situation with rights-of-ways is an umbrella CCAA. And that's where we develop one overarching agreement with multiple cooperators working together. And then each property owner receives individual CCAAs and a permit that's tiered off of this umbrella agreement. And there'd be like a list of conservation measures. I think of it as a menu, or this template that I was talking about. That'd be like, you know, almost like a checklist. Here on your property, here's the things that you would cover. We'd have it all set up. So yes, the Fish and Wildlife Service would have to be the one that signs and approves those individual CCAs, but we would make it so that it's so seamless, hopefully, that it would go very quickly. Not like each time, we wouldn't be negotiating each time a new CCAA. It would be that umbrella that would be the discussion document. So as I've said, what happens if this species is listed? That CCAA stays in place. You, the property owner, continue to implement the agreed upon conservation measures, and that permit, the enhancement of survival permit, would go into effect. And if there was any incidental take anticipated because of the conservation measures that you were taking, those would be covered under that enhancement of survival permit. And then we wouldn't require the property owner to take any additional actions than what is in the CCAA. So applying this programmatic or umbrella CCAA, we would process these applications for a certificate of inclusion or this umbrella CCAA, which is what I think would work better, all the way up until the final listing decision, if there is a final listing decision. So as I said earlier, the monarch, we have to make a decision on whether or not to propose the listing in June of 2019. If, that's a big if, we propose to list it, there would be another year that we'd have to make a final decision. So it'd be in, say, June of 2020, if we propose to list it, then we'd have to make a final listing decision. So that's roughly the time frames of when you would want to have a CCAA completed. As I mentioned, like the yellow-banded bumblebee is earlier in schedule. And that would be something that we might want to consider covering, but it's got a little shorter time frame. And again, we would have to propose to list that, and then have a year after a proposal. So there's a little bit more time than maybe some folks are thinking to get one of these done. And the big difference is, if one's done while we're still in this process, like even after it's proposed for listing, but it's done early enough that we're not like at the brink of a final decision, we can consider did that alleviate the threats enough that maybe we don't, in the end, have to list the species, even after we've issued a proposed rule? So again, I think there's huge benefits in the idea, with the amount of habitat that's potentially available through the rights-of-way, of hopefully affecting our ability to reduce the threats enough that we wouldn't have to list the species. So a couple of examples where listing didn't happen because, in part, of CCAAs was the New England cottontail and the greater sage grouse. As some of you have probably heard, sage grouse is very complicated and has a lot of other moving parts, but CCAAs were also instrumental in affecting that decision on not listing the sage grouse. So, okay, that's it from me. Now we're going to answer questions, and we'll have more time tomorrow to have the discussions.